Hello, I am audible. Can you please confirm anybody in write in the chat box if I am audible? So we will start. Okay, thank you so much. So, greetings everyone, and a very good afternoon to all of you. I welcome to today's webinar on conflict to collaboration, mediation skills for the next generation, organized by Legal Vidya. My name is Paras Chug, and I will be your host for the today's session. We are thrilled to have you join us as we explore this increasingly critical topic, which is becoming essential for legal professionals and aspiring mediation specialists. Building a successful career in mediation requires a deep understanding of the evolving legal framework, along with key skills, knowledge, and strategies to navigate this complex area. Whether you are a law student, practicing lawyer, or a professional looking to transition into the field of mediation, this webinar will equip you with valuable insights. We will cover the essential qualifications, practical experience, and strategies needed to thrive in this fast growing sector. Mediation offers vast career opportunities as organizations and individuals prioritize alternative dispute resolution methods to resolve conflicts effectively without the litigation part and without the judicial part. Today, we will focus on understanding the key concepts of mediation, exploring the best career pathways, and learning how you can position yourself for growth in this field. It's an invaluable opportunity for all stakeholders to enhance their understanding, improve career prospects, and contribute to effective resolution of disputes through mediation. Now, I am pleased to introduce our esteemed speaker for today's webinar is Ms. Chandrika Joshi ma'am. Ms. Chandrika Joshi ma'am is a distinguished company secretary, advocate, and an IMI qualified mediator. She is also a partner at Chintan Bhatt and Associates, a renowned practicing company secretary firm based in Ahmedabad. With over 5 years of experience, Chandrika ma'am has been an integral part of the legal team at Chintan Bhatt and Associates. She is handling over aspects of legal frameworks, drafting, documentation, and managing legal cases. Her expertise in mediation and legal practice makes her an exceptional guide for this webinar on conflict resolution and collaboration. This webinar is being recorded and the recording will be shared with the all registrants. I kindly ask all participants to keep their microphones muted and cameras off during the session. And please save your questions for the end. A feedback form will be shared during the webinar, so you have to fill that form and please don't ask the form. Our team will share the feedback form. And without further delay, let's extend a warm welcome to Ms. Chandrika Joshi ma'am. We are excited to hear her insights. The floor is yours, ma'am.
Thank you so much. So am I audible?
Yes, ma'am.
Okay. So firstly, I'd like to thank you, Legal Vidya, to have me and on this topic, mediation collaboration for disputes. So basically, in upcoming 1 hour, I will share like my experience for a mediation as well as some mediation skills which are required for a mediation to be like for a successful mediation. How a mediator serve his skills and how he or she a mediator can resolve the disputes more smoothly. So, firstly, I would like to share this PPT for all. Let me share this. Is the screen is visible?
Yes, ma'am, it is visible.
Okay. So, firstly, I would like to explain what is mediation and what is this topic about. So, if I'm not wrong, all are from the legal background, obviously. So, all were known to the alternative dispute resolution process. So basically, alternative dispute resolution is come from or enforced from Civil Procedure Code 1908 CPC from Section 89. Section 89 gives a power to the court so that they can refer the cases to the out of court settlement, in which they have mentioned 4 to 5 process which are covered in a out of court settlement. Okay, but you can see that in that process, in that section, there is not a word for a mediation. Actually, the word mediation is not defined anywhere in CPC and in Arbitration and Conciliation Act as well. Because mediation is there in India, the concept of mediation is not much known and aware by the people or by the in the legal profession as well. Actually, they are using the synonym word conciliation. Most of the person like all were known to the conciliation also. So all were thinking like, okay, the mediation is the conciliation, they both are same, so they're using synonym word for the mediation is conciliation. But in 2021 the bill was passed, and in 2023 the act was came up with in India, that is Mediation Act. The Mediation Act is the act in which the proper mediation stage and the mediation enforcement is come into the India. Like now the legal process is there. Everyone knows in India, if you want to go to the mediation, you can go to the legal process. Before 2021 the bill was passed, before that they all were using arbitration and conciliation process, and they are using a private institutional process for mediation. So there are so many institutional mediations in India. If you were known about Hyderabad, the International Arbitration and Mediation Center, if you were known about the Delhi having the arbitration and mediation centers, they have and in Delhi also there is one more mediation centers. So these are the institutional private institutional mediation centers. But these are they need some legal body, they need some legal authority to enforce the mediation bill. They are enforce the mediation agreement, which is known as a settlement agreement, where the both the parties agree, okay, these are the terms and conditions, we are agreeing on that. But these are, they must have some legal base over there. So now in India we have now the Mediation Act 2023. So basically, what is mediation? First, we have to know that what is mediation. In Section 3 Act of Mediation Act 2013, the mediation includes a process. Now, this mediation is the process in which the both the parties, the disputed parties, there is one, obviously one is the aggrieved or a victim party, and the other is a defendant who he wants a defense. Okay, so they are the two parties and they want a solution. They don't want to go a court litigation. They don't want to give some time in the litigation process. No, they need a very smooth and quick decisions, quick solution. That I need quick solution. So for that, India in a court, the bill, the act has been introduced in Act 2023. So mediation, now the mediation is officially a word in our legal process. We have this word now. Now it is defining. We can say that it is defined in Mediation Act 2023. So this is so which includes everything. Like now mediation is a very wide process. Now you can see we can add a proper expression mediation, only the mediation word. It can be a pre-litigation mediation. Pre-litigation mediation is also a very different concept, and it is mentioned in Mediation Act 2023. If anyone who have interest in ADR and in a mediation field and want to go in a mediation, then they must read Mediation Act 2023, because each word which you have seen in this definition are defined in Act only. So pre-litigation mediation, online mediation is also there. So it's very popular right now. Like from last 3 to 4 years, I am very much interested, and I'm working with some companies as well for ODR, online dispute resolution, in which you can maybe you all have listen the name of Sama. That is a ODR platform. So basically ODR now there's one more thing. It's a online mediations. Okay, so that means somewhere we can say if a mediation, if a dispute resolving through online are also legal. Now we can say yes, it is mentioned in the online mediation. That means we can resolve the cases through online and it is legal process. But before 2022 23, it is not a proper official legal process. Okay, we are doing just for the private thing, but it is now a proper official thing. Now the community mediation conciliation, now this is here. Mediation includes a process, that means they are including conciliation as well. So that's why there is a confusion where a conciliation and mediation word are using synonymous, because the process is almost same. That is why. And or an expression of similar import. So basically the mediation is a process in which both the parties come and reach to an amicable solution, the main settlement thing where they both the parties agreed to something, disagreed to something, and in last they have agreed to do these things, and in a upcoming 180 days or 6 months they have to enforce such settlement agreement. So that settlement agreement is also defined in mediation act, which is known as a mediated settlement agreement. So that means if a mediator is present, both the parties are present, and the mediated settlement agreement is there, then that agreement must be enforceable by according to the jurisdiction of the court. Wherever the jurisdiction, wherever the court case comes from the court, we can go to that court and enforce that settlement agreement. That's it. Most of the time, like a maximum time is 6 months. That means if you having a case, having a dispute, you have a solution within 6 months from the date of entering into the settlement agreement. So how easy and how quick it is, that is a mediation, and that is why it is an alternative dispute resolution. The other way of going to the court litigation, you are going to the mediation thing. now now, up now, there is one word. If we are saying this in this definition, is a mediator. This is a very big question in India. I think I have written my research paper in there in 2000 back 2021, that who can be a mediator, because now there is clear, yeah, that now there is a definition in Mediation Act 2023. But before that, who is a mediator? How you can be a mediator? So there is not a single definition that who can be a mediator. At before 2023, anyone can be a mediator if you having a good communication skill, if you're having a good legal knowledge, if you are having a good emotional balance, and you can understand the party's problem easily, you are a mediator. That's it. It's a very vague and very vague concept before 2023, but after this act we get a clarification. At least we get a clarification that who is a mediator. So Section 3I of Mediation Act defines a mediator, a person who is appointed to be a mediator. Obviously, but who is appointing a mediator? It's a very big question. Parties himself are appointing up, because the parties are the main authority. If we say in ADR process, in whole ADR process, if you know the arbitration, then you can see that okay, in arbitration also the party autonomy is more important. So parties are more authorized person. If they want this person as a mediator, then that will be the mediator. Okay. Now, by a mediation service provider. Now, who are the mediation service provider? This definition is also given in the act, but slightly I will explain. Mediation service providers are any person, like any organization. It can be any ODR platform. It can be High Court, Supreme Court, any institution, like we can say that private institution, they all are covered in mediation service provider. You can easily see the definition of mediation service provider in section 3 only, and in a Mediation Act 2023. Now, to undertake the mediation and include a person registered as a mediator with the council. Here the council means that High Court and Supreme Court having their own mediation centers. Okay. So if a person, if a advocate having a more than 10 years of experience in his like in advocate in his legal background, then he or she can be eligible to enroll as a mediator with the councils. So that he is a Supreme Court maybe, and the High Court also. So this is a mediator. Now, no, it's not only that much. I just wrote it because of it's a very wide concept and it is very wide, but my focus in this webinar is only on the mediation skills. I will share the skills with you so that you can you all just get a knowledge of how a mediation actually performs. So that's the main focus on this mediation skills only. So basically, private institutions are there, so they are also providing so many trainings, and High Court and Supreme Court are also providing the trainings. So for the official government mediator, if we are saying that a government mediator which are registered with a High Court and Supreme Court, they are providing a mediation training of 40 hours training. You all must like maybe you all aware about that 40 hours training, which is which is very important for the mediation, because I have also gone through that 40 hours IMI mediation training, because at that time I have completed my IMI training in 2021. So yeah, in 2020 or 21. So at that time there is no as such act, and there is no much awareness about the mediation. At that time I have gone through that IMI training, because the IMI, International Mediation Institution, was the only official authority who is enforcing mediation in India as well. So you can see many of the experienced advocates and many of the experienced mediators are the IMI qualified. So there is a biggest institution is the International Mediation Institution. The training was 40 hours training, and that was amazing. They give like many role plays. They are giving like lifetime real life situations and cases where you have to tackle those things, how you are tackling those things. These are the basically mediation skills. So that was you required, and that is given in the training as well. So there is a High Court training as well, and there is a Supreme Court training. So the training make a person an advocate as a mediator. Now you can see in a Mediation Act 2023, after completing like this, after this ending the webinar, if you can see, there is no qualification is mentioned that who is a mediator. There is no proper qualification. Anyone who is going undergone the training of the mediation, if he have that capability, he can be the mediator. Even a science background person is also a mediator if he have that capability and skills to resolve the disputes very quickly. He's understanding the things, then that means he is a mediator. Okay, so this is a very like I can say that it is a very good for the purpose of a mediator, that anyone can be a that person. Now, so what is the main purpose of a mediator? So there is it comes in the picture that why what a mediator have to do. So mediator have to do only one thing, that is to make the parties such a convince over a one main problem or one solution, only one solution, where they at the when the mediation starts. If I share one of the experience of me in a family dispute, where I am assisting a mediator, okay, in a Rajasthan High Court. So there is one case of a family dispute where where a husband wants a divorce and the wife don't want to give a divorce to him. So court passed like send the case to the mediation, so because they can easily solve it in 2 or 3 settings, the mediation completed. But in that case what was happened, actually husband have his external affair and marital affair with someone, and he want a divorce from his wife, and wife didn't want, because they have a children, and she was like, I don't want to give a divorce. Now the now this trick is come into the picture. Now what a mediator do, how mediator convince someone to give a divorce, or how she convince the husband to not to give a divorce. So this is a main purpose of a mediator, to come into the one picture and reach a mutual agreement. That is main things. And it is very difficult, if and as I'm saying, so it's like at the time of listening, it's feel like it's very easy, we can say this, we can say this. No, we can't say any of the things. In our upcoming slides, I will share that what actually a mediator will do. So after, at the end of the webinar, you will literally feel that it is a very tough job, very tough job. In India, mediation taking very lightly, mediators are very lightly, because they think, okay, just do this thing and that's it. No, actually, if you gone to any international training, you will literally see that they see the seriousness of the case. Yeah, they see the value of the mediator. So that's why IMI training I literally suggest, because in a introduction, legal vidya actually say that if this webinar helps you in a career in the mediation, I will always suggest that please go to the international training instead of Indian training, because international training will give you the real picture of a mediation. In India, still we are working on it, and the stage is not that much clear. So, so next thing. Now the important thing is, have to clarify, identify the issues. What are the issues? Why any party want to give a divorce and other one don't want to give a divorce? How we can get it from the parties itself, how we get the information from the parties. That's a very important thing, and it is not easy. It is not easy. I'm literally, I'm sharing the experience of my practical experience. And where I have seen that the parties are so rigid, the parties are very hard to give the information. They don't say each word. They always, they are using the words which are protecting himself, but they are never accept the fault. They never accept the things that they never want to reach into the mutual agreement. No, the Indian mentality is to go to the court and make the process so lengthier, so that other party will stressed, and literally they fed up of this process. They only want other party to get tortured. This is the Indian mentality which I experienced. But if I go to the theoretical part, yeah, it's basically identifying the issues, encouraging information sharing, and exploring solutions. So it's a in a theoretical, the mediator helps the parties to in such a way. Now the main purpose, what type of mediation skills required for mediator? What type of mediation skills? So basically, in a very simple way, if I told, obviously we need a communication. We need such a communication. The communication is not that much, like it's not means that okay, I'm communicating to the parties and we are chit chatting with each other. No, no, that's not a communication. Here the communication having a very different picture and very different definition. So, so first is communication. Actually, the communication means in, and it involves a listening part. It's a very important thing, a listening part. Mediator must have a good listening power. If he have a good listening power, then he have a good communication, because he listens. He listen all the part of all the things of that information of the parties, and then on that the information he convey the better solution, he convey the best thing. So communication is very important. Now in if you just read it, okay, what's a big deal, it's just a communication, we will communicate. No, we can't communicate so smoothly and so frequently. No, we can't, because a mediator is not an advisor. A mediator is not allowed to give any advice, anything to the parties. No, Mediators are not allowed to that. Mediation process is very different process. It's an informal process, but involving a very having a very like boundaries within the mediators. Like mediator don't do anything which are exceeding his boundaries. No. So basically, now these skills I will explain you with a one practical example. Okay, so I have shared the one example that where a husband wife wants a divorce, a husband want a divorce, and wife don't want to give a divorce. Now the communication starts. There are three sessions. First is a communication, where the communication plays a role. I am saying that in each part there are three sessions. First is a joint session. Like joint session is first meeting, because mediator don't know each party, don't know. He actually, he or she actually see the first time the parties, that what is actually the picture, he don't know. So he needs some background over their case. So and that background comes from the parties itself. So it might be a very much information. There are lots of information you don't remember, that what he's saying, what she's saying, you don't remember those things. So for that there are some skills you have to require. So for that you have to be a very good listener over there. So you first you go to the joint session, in which you will see that they are introducing themselves. They are giving facts about the case, that this is short and simple. There's maybe in a first meeting you will go to the joint session. Okay. And at that time the communication plays a very important role, because in communication it involves the questions. The questions is like you are saying that first you have to introduce themselves, like like this is the mediation process, what is this about. You are conveying this information very clearly. You are saying these things, you are saying the concerns, like you are explaining the mediation process whole, that what is this, because it is very important. In India still, I will say that 80% of the people don't know what is mediation. Literally don't know the what is the mediation. So first a mediator have this responsibility to must aware the parties about the mediation process. It is very important, and it is a part of communication. If you don't aware the parties will say that okay, this is just a time pass, what is happening, we don't want to go this thing, we have a solution, we won't need a solution. So we have to aware them about this process. So first there's the communication place. Now just make a good like connection between the parties. How it will help, that first mediator will strictly, like you have to be strict, you have to be polite at the same time. You don't use the rude words, you don't use those languages, and you have to make the rules clear to the parties as well. Like you don't use these abuse words at the time of mediation process, please avoid it. So you have to say these things to the parties. So that's why party will respect you in the whole process. At the first meeting, the first session is very important. That's why I write a first skill was a communication skill. And the communication skill is not that the chit chatting thing, it's a thing which is helping you to the connecting with the parties in the first session, and which help you in the whole mediation process and after that also. So that's why now the facilitating role is very important in in a mediation. As mediator is not an advisor, he is not allowed to give any legal advice, he is not allowing to give any strict things to do to the party. He can't say that you have to do this thing. No, he can't say this. He was just a facilitator, only a facilitator. He can't even suggest the things, he just gave the points, he just put the things over there. Okay, you are having this type of options, now you have a choice to take or a opt one option. So this is the communication skill, and it is very important. I must say, even you don't have the other skills, but you should have that communication skill, and that communication skill will help you in resolving the case or resolving the dispute very easily. If you don't have the other things, it's okay, it's very fine. And always avoid the questions related to the why why you are doing this, why you are give want to, no, don't ask any type of why questions to the parties. Always use what, how. Like, because what, how will give the more connecting answers to you. Because why is that means, okay, that why you are doing this thing, that is doing in the court only, the advocates are doing these things. So you are not an advocate, mediators are not an advocate. This is the thing. But in India still they are confusing that, because the advocates are the mediators and the advocacy things comes in the blood of the advocate, and they use these things in the mediators. So that's why a mediator must undergo the training thing, and that's why they know the reality of the mediation. That's why the training is very important for a mediator. Now, conflict resolution, obviously, mediators should have a range of conflict resolution techniques. There are so many techniques. Now, tell you two or three techniques in a negotiation, because negotiation is very important in mediation. If you are going to a mediation, you must have that negotiation skills. So first, a negotiation has been done, then a mediation actually parallelly it is happening, and in a negotiation is very important role. Now the negotiation, there is a vatna, there is a batna, best alternative option. We have to find out the best alternative option, and there is a what is the worst alternative thing for the parties. So there are some techniques, there are very much techniques, just to find out, to focus on the goals and not on the problems, focus on the solutions, not on the problems. So there is one vatna and vatna, worst alternative to the negotiable agreements, and best alternative to the negotiable agreements. What is worst? First you have to find out that what is the worst thing to the parties. So just get out the information from the parties. Okay, in joint session they will give you the background, and then you can go to the separate caucus, that is separate sessions. Like, first you have to take a victim, always take a victim or every party the session, okay, because he is the victim and agree party, he is the person who initiated the thing. So just go to the first separate session will be taken to that. Apply needs to add that time of sessions. Yeah, just take out the confidential information from them, that how this happened. Ask them, okay, how this happened, what are the consequences will be there if you are doing this. Just realize them that you are doing the wrong thing, not by saying this, but just to get them to say this. Okay, so you have to ask them. In separate caucus you will apply the other skills like a conflict resolution. It helps the parties to resolve the dispute. The techniques, different techniques, you can just apply emotional things like if you do these things, you have these consequences. Now let's now think about that. Okay, that how this will end up, how you will suffer from these process. So these are the different techniques you will use. Then get out the best alternative, which are very good for, which are best alternative for both the parties, where both the parties agree, okay, this is the best alternative for me, this is the best alternative for me, and the mediator will stick to that thing. In separate caucus, definitely you get the confidential information if you go on to a 3 or 4 separate sessions with each parties in, and you will, because parties get a time, and parties like adjust and be like we can say that confident with you, like coordinated with you, like okay, they trust you. So build that trust thing with parties. It's a very important thing. Now this trust thing is also a very good skill between a party, that mediator must have that skill, that he can easily gain the trust of the other ones. If you have that skill, like anyone can easily trust you and you can easily convince the other parties, that means you have that mediator skills, and it is very important. And it is not like that you are practicing these skills, no, it's a very genuine and your personal skills. As a person, if you are saying that are you having these type of skills, if you are having these type of skills, that means you are a very good mediator. Now, empathy, where this is very important. Empathy, not a sympathy. Empathy, you have to understand what is the party's perspective, what they are thinking of, what they are going, like what they have gone through, the things they have suffered. You have to come into his or she pictures. Like you have to put your shoes into, like your lives into the shoes, like we can say that. So just come into that place and then think, okay, if she is saying that she don't want to give a divorce and she having a children, so what we can offer, the best solution to her, what would be the best solution for her? Okay, we convince her कि like, see, you can't live with a person who don't want to live with you. So how you can live with him? We realize the realities to the, so just see the perspective of each party and then display the empathy. And that is very important, because in separate sessions you get connected with the parties, and much more you get connected with the parties, more the parties will connected with you, and they help you to get a better solution. Literally, mediator is just a source or just a medium, but the parties are the only heroes who help you to reach the one solution. You are the source, because they are not ready to talk each other. They literally don't want to talk each other. If they want to talk, then why they came there, like in a court? They don't want to talk to each other. So we are the mediator, is a source, is a medium, is a third person who is helping these two things, these two persons to come into a solution. So that's why empathy is very important. In real life also, in real life, I believe that if you have the empathy thing, you can be a very good mediator in a professional way, because it helps you to understand the other's problem very easily. Now, the neutrality skills. Neutrality is a skill, we can say that actually how it is a skill. It is a skill if in case, I give a one example to you. For example, like you are you and you have a two best friends, so you are a three best friends, okay. Now there is one big dispute has come into the, like, has started between the two friends, and you are the third one. Now the one friend come to you and say that, well, how he is doing these things to me, I don't want to talk to him, I really don't want to continue my friendship with him. First one person comes to you, the other person comes to you, the other friend comes to you and saying that I don't want to be a friend. You know, there is a chance that you have to choose, you either me and her, yeah, him, as a, like, there is a dispute, okay. Now you are the third person, you are the mediator now in these two things. Now, wow, how you maintain the neutrality over there, because you are the friend of both, you both are like, both the persons are the friends of yours and the equal friends. Now how you are maintaining that neutrality and impartiality in that, and that is the skill where we require in a mediation process. Because if you are not neutral and you are partial over somewhere, like for example, if you find that, okay, that other person is rich and he is like he is providing you many luxury things and gifts to you in a birthday, and the other is not that much into that, you choose, if you are money minded, then you will choose that friend. Okay, I will live with her and I don't want to be a friend. So that's not the picture. Then that means you can't be a mediator. Even though you will read, you will go to the 40 hours training, you can go it. But no, because in mediation, that neutral thing is very important. How? In my practical experience, where I was assisting a mediator, where I have seen that my senior is also a lady, like a mediator, so she is also a female. And when the case came to on a table of a divorce case, the female, as we are a female and as we have that emotion and concern with the female, obviously more, because we see that, oh, how she is crying and how she handles these things with her child, how she managed. So somewhere there are chances that we can emotionally flow over to the woman. There are chances, they are 99% chances we go over there. So that is the skill where we have to control our emotions, we have to control everything, and we have to remain a neutral. I don't care. I really don't care what she will do, what he will do. I have to do one thing. That is a one solution to both the parties. That's it. So at that time, I really experienced this neutrality, and I feel that okay, this skill is very important because it helps you, because you don't know each party. You have to maintain an impartial thing, and you have to take a one decision, even the that female is crying, even if female is not feeling good, no, doesn't matter, we need one solution, we have to close this chapter. We can't open this with from the for the 5 years, 6 years. No, we have to close this chapter. So we have to maintain that strictness and the neutrality throughout the mediation process. So this skill is very important, very important. And in real life also there's this, you can practice these skills in real life cases also. Now the patience and the flexibility, if I can see that a mediator must have that patience. Why the patience comes into the picture? If you see in the real life cases, comes in the high court, and you will see literally parties are not are literally are not interested in talking with the mediator as well. They don't want to sit. They come with them advocate, and the advocate will say, okay, my parties don't want to sit with the other one, my party don't want to say anything. But that's the thing, now the mediator have to play a role, be patient, be flexible, but have to stick with the rules. Okay, this is my rule, this is my rule. Because in a mediation process, even the parties are the heroes, but the control and the authority is always being with the mediator. So here the mediator must use that authority and use those things, and then make the things clear. Okay, this is my mediation, and I will order, yeah, not order, I will just tell the parties that you have to go through the mediation process, because this is the process. If you don't want to sit with the other parties, no issue, we will take a separate session with you. We can do it. It's a very flexible process. You can go to the separate session at the first meeting also. There is no need to go a joint session only. No, we can go to the separate. And I have seen many cases where the separate session is also happening, where the other party didn't come to the mediation, literally, but we can't adjourn it, we can go to the separate session. We we just know the picture of other parties, and that's it, it's included in the first sitting. Now the second sitting we get, okay, now this mediation will heard on that day. Then the other party come, then other party will say, okay, this is my part and this thing. So this is very flexible process, and mediator must have that flexibility in his thing. He can't be a rigid over there. No, we will go to the joint session only. First there is a this. No, he can't be that rigid over there. There must be a flexible in that nature. There must have the patience over there, and yeah, and as the it is written here is parties may have a different communication styles. There is a language barrier also. I must say that if you are taking a high court cases, then there are much better normally local parties over there. So the local parties, they have some language issues, because they are not, like, they are professional persons, but they are not the professionals. They are just the normal persons. They don't know that how to talk in front of a mediator, that mediator who is a high court mediator, but they don't know what is, and they even don't care. They are they are having their own communication style. At that moment, if a mediator also being like a very strict and attitude person, and he's also saying that, then that's not a mediation. And here the patience plays a very important role. You have the flexibility, you have that patience, and you don't talk like a parties, because then, but then how, what is the difference between you and the parties? That's very important. now. And these skills please apply to the in a real life situations also, because that in real life situations these skills will help you to become a very good mediator in a professional. Now next was a problem solving. That is a problem solving is a very common skill you all have. We are solving thousands of problems in a day, because if like for example my parents are not agreeing on a one point. My mother is saying I don't want to cook food at night, and my father, no, I have to, I want home food cook home food, like I want that. But now this is also a dispute. We can say that this is a problem. Now how we are solving this problem? Okay, we can do it 50-50%. Okay, you just cook this food. You can cook chapatis, when we will bring like a vegetable and our like dinner, half dinner is from the restaurant, we are ordering from the restaurant, so we can just go to the one way. Okay, what is a common point? Okay, this is a common point. So we are problem solving, these things are very common, and this we are using the skill in a very in a day to day life. So that's, but the important thing is that the bigger the problem, bigger you require the problem solving skills, because the disputes are not that much of home food cook or like restaurant cook. No, that's not the problem. This is a very small problem, very small problem. These are parents, because days we are having a emotional connection. At that time mediation, the parties are not known to the mediator, and they are very in a very aggressive mode at that time. So the bigger the problem, bigger you require the problem solving skills, and you have, and in that I must say that problem solving skills we required communication skills, very very important communication skills, and listening skills, active listening. We required active listening, not just a listening. Active listening means when the parties are sharing their information with us, we add in the mind, we are just providing, we are just thinking about the solutions. Okay, we can do these things. That is active listening. At that moment, if you are creating the solutions in the mind, that means you are a problem solving skills, you're having that skills. So that is very important for the resolving the disputes. Now now this skill I already mentioned you, that building trust and rapport. Build, like we can say that a mediator must be very careful to devote equal attention. And this is it literally. I have seen this thing in the you if you will go to the practical cases, you will see that parties literally blaming mediator, that you are giving chance more chances to the other party, you are giving more chances to that thing, you are saying very soft things to the other parties, he literally blaming the mediator. And where if the party blaming this thing, the mediation will close, because the main root, the main thing of mediation is the impartiality, the that impartiality, that neutrality. And if the other party is blaming the mediator, that you are much more into the other party, that means you are not able to gain the trust or build the trust of that party. That's why he is creating the doubts towards you. So it is very important in a mediation process that must pay equal attention to each participant. You have to be that if you are asking one question to a victim, then you must have asked that type of questions to the other party. If you ask, if you are giving the equal time, there is a time duration, they are very important for time duration. Like if you are giving 10 minutes to the victim for the separate sessions, you have to give a 10 minutes to the defendant party, even though his session is completed in the 5 minutes. No, what happened in the second or third sitting, then other party will come into the suddenly and say that okay, you are giving a much more time to the other party. They will just say it one line and the mediation closed. Because and once the party raise the issue on the neutrality and impartiality, literally the mediator is not able to resolve the case, that case by himself. No, So in arbitration also these issues are came because in arbitration also the parties literally raise the issues on the neutrality of the arbitrator, because the arbitrators are also appointed by the either by the parties or by the court. And in mediation also the mediators are appointed by the court or by the parties. Most of the cases court refer the mediator. So the parties are like, they just have 1 minute and 30 seconds and they just blame the mediator that you are not a right person for us. You are involved with the other party. Just one line and the case resolved. So this is literally this is happening. Okay, so this is, I must say the trust building will always come from the communication thing. That's it. You have a best communication, you have the best thing, then you can build a trust. And if you once you gain the build gain the trust of the other parties, they will easily share the information with you. You will definitely resolve the cases. Now there's just one quote I have just read somewhere, and he's a very experienced mediator and instructor, where he say that the client has the answer to their problem. Literally they has the answer to their problem. They already know, they already have their make their minds and set mindset, okay, this is my solution. But they just have, just they come to the table and just they want that solution from the mediator. They actually they want that. So, and it's our role, like it is our role, that it is a mediator's role to bring forth those moments of awareness and revelation. That's it. That's the line which I really loved and really like these lines. So I like that. Like I will share this thing to all the participants. Like that, literally the client has the answers of their own problems. So these skills develop during mediation training, and when we do more, like I already said that. She also saying that, and every experienced mediator must say that for a mediator you must undergo that 40 hours training. That is very important, because that mediation training helps you to see the real picture of the cases, the real situations where you play a role plays, like you would be the one time you would be the party, you would be the other party, then one time you would be the mediator, because you must know the party's role as well. Because if you know the party's role, you can easily solve the problem. How the party think, how party make the confidential information. So these are very important. So students learn how to ask goal directed and future oriented questions. Definitely. That's what I already explained you. The question asking questions thing. Like questions, that means don't ask why. Why this happened? Why you do this? No, no, don't ask why questions. Ask how this happened, how we need a solution. So now what you are going to do this, now what is your next plan, ask them. Ask a future oriented questions, because this will give the solutions to you. And so clients can move forward and begin discussing goals and strategies for the change. So because you will aware, you will motivate the parties to go to the solution, you go to the reach that solution. The mediator have to do these things, and it's a responsibility of the mediator. So that's all from my side. Basically, these are the skills which I have selected from almost, there are almost 30 40 skills for a mediator. Actually, I'm for my personal experience, if I say that that is not the number of skills which you require. If someone have a best patience skill, okay, if someone have a patience and flexibility skill, he can do everything, literally. If you have that active listening skills, yeah, so there is not a number of skills that you must have that 10 type of skills and you are a mediator. No, no, that's not the case. The case is that you must have the knowledge, the understanding, and that patience and empathy with you, so that you can understand the party's perspective and party's problem. So that if you can understand the problem very easily, you can solve that problem very easily. So that's all from my side. I hope you liked it, and I hope this webinar helps you to to understand how mediation works and what are the skills of a mediator we require and we need. And that's the topic of this webinar. And which means that for the next generation, like upcoming generation, having a very good platform, I must say, because because now the knowledge and now the awareness are literally through the, we having a social media platform. They're like a legal media, we can say that. Now the legal media is a medium and source through which you all get to know that okay, this is a like this is all about how you know that what is mediation skills, how you get connected through me, how I connected you all. That's why, because through the media, now this next generation and in upcoming generation, I think mediation and the area is a future. I don't think that parties and companies want to go towards 5 years, 10 years cases. They really want to resolve the case within 1 year. Arbitration cases are resolving within 1 year. So this is a future and you require. So I suggest that always, if you want to make a career in a mediation, go to the international training instead of India, because international training will give a better picture of mediation. So that's all from my side. Thank you.
Thank you so much, ma'am, for taking a wonderful session on mediation. There are some questions from the participants. The question of the Mahima Sharma, ma'am, how can we apply for being a mediator?
Yeah, okay. If you want to apply for a mediator, so there's a first thing is you, if you are law graduated, okay, if you are a law graduated, you can go for that. And I must prefer that first go for the post graduation thing. If you are post graduated, then go for the international mediation training. Just search on a Google and write what are the authorized mediation training institutions in India and in globally. Okay, when you put out I have done my international mediation training in the London based, UK based firm, which is a mediation firm. Okay, so I have completed over. And so I just contact them, I have apply for them. There is a fees, obviously the international fees are more like expensive and costly, but it's worth it. Okay, it's a worth it. So you can just apply directly to the institution, just search on the Google and proper, and you can see in the LinkedIn as well. Research more to the institutions, and always see the authorized, international mediation, it's a Singapore international mediation, simi. So you can go over there. And there are so many international mediation institutions, and in India now they are all are accredited IMI trainings. They are conducting those IMI trainings. So you can see these in a Google, and you can apply. My training I have conducted in Sunday, like Sunday 2 to 3 hours, Sunday, Saturday, Sunday. It's a very flexible and it's an online. If you are going for a offline training, I will suggest one more. If you are, like you asked me, that's why I suggest you one more. It's a ADR ODR international training like they are providing a training. They are very authorized, and they are ADR ODR. You just search in a LinkedIn, you will see that they are providing offline mediation training. If you get a chance, you must go the offline mediation training. That was a very like different experience with you. So I just suggest you can apply easily, very easily. It's just a form filing, pay the fees, and you enroll yourself with the that. And then the for a future, I just suggest that when you research the one institution and you are applying for the training, you just connected to those all those authorized bodies, the experienced one who are providing the mediation training. Please get connected with them, and just after IMI qualified, you have to go for the, I think, 30 or 60 days training under a experienced mediator. So then you will be the IMI certified mediation. So you have to go 60 days, and then you will, that process will automatically, you will get to know of your experienced mediators, the training providers.
Thank you, ma'am. As we come to the conclusion of this insightful and engaging webinar on conflict to collaboration mediation skills for the next generation, it is my pleasure to extend a heartfelt vote of thanks to all of you for being a part of this session today. First and foremost, I would like to express our deepest gratitude to our esteemed speaker, Ms. Chandrika Joshi ma'am, for sharing her wealth of knowledge and expertise with us. Your expertise and valuable insights into this field of mediation have provided us with a clear roadmap of building a successful career in this evolving and impactful area. We are truly inspired by your words and grateful for the time being you have taken to guide and educate us today. A special thanks to all of our participants for your active engagement and thoughtful questions. We hope this session has given you the tools and the inspiration to explore the exciting opportunities in mediation and take meaningful steps towards a successful career in this legal field. Once again, thank you all for presence. Thank you, ma'am, for taking a wonderful session, and we look forward to having you with us at future events. Have a wonderful day ahead. Thank you so much.
Thank you so much. I'm seeing that all are happy. I literally seeing the things. Thank you so much. Thank you.
Thank you, ma'am. Thank you, participants. Have a good day. Happy learning.